You're listening to the Valley Current.
Well, welcome into the Valley Current, Steve. And I know you've got a good topic because we've been probing it back and forth for probably the last couple of years, which is what are the tax ramifications of folks that do the SAFE agreements versus the way folks have traditionally done these convertible notes. And just for the sake of background, in general, when companies get started, they often don't immediately get venture capital. In fact, these days, the Series A rounds are so delayed that there's friends and family money that has to come in, and that typically comes in not as common stock, but rather as some form of debt or quasi-debt. And I say quasi-debt because a SAFE note or a SAFE agreement is not strictly speaking identical to, it's similar to, but it's not identical to a promissory note or a convertible promissory note. And it was created by a lawyer at Y Combinator to say, hey, we can simplify this process so people don't keep spending cycles negotiating paperwork by having a standard, quote, SAFE form. But it's really, the word SAFE is kind of a double entendre misnomer, because we did a podcast about how safe are SAFE agreements, because SAFE itself is an acronym that has to do with a secured agreement for future equity, or whatever the S word means. But it's essentially like an option that is to get into a round based on certain discounting terms. But if the business fails, I think that option more or less expires, as opposed to being converted into being debt, the way, say, a convertible note would be treated as debt. But you just pinged me with a bunch of stuff about stuff that you learned about how different people are viewing SAFE. So why don't you give me your view of what's going on in the area?
Well, good afternoon, Jack.
I
And before we go any further, there should be a disclaimer that nothing we say is guaranteed and not to be considered legal nor tax advice, because I'm not a lawyer. And
I'm not an accountant. It's a perfect non-responsibility.
This stuff is
fingers at each other with no one being responsible.
Constantly changing. And so nothing we say really is guaranteed without a consultation on the detailed facts and circumstances surrounding your situation if you're listening to this.
Right. And let me say something else. I don't think that lawyer who did the SAFE agreement form for Y Combinator was thinking tax at all. In other words, I don't think that person was actually thinking, oh, I'm going to be worried about the tax ramifications of this. I think it was a woman, all she was doing was more or less saying, I want something that won't be negotiated over and over and over again, the way a lot of promissory notes are. And people were wasting a lot of cycles with lawyers, not wasting, but essentially burning a lot of cycles, because the minute someone gets a promissory note from a company, they think, oh, it's a very one-sided deal and, simple agreement for future equity. That's what the acronym means. Simple is the S word. And conceptually, it's like, we don't want to spend all those cycles, and we don't want to spend the legal fees on renegotiating a promissory note. We just want to say this is the standard agreed upon default form. And of course, many clients issue these things like their tissue paper, and they don't even necessarily get the board resolutions to do them. They just have a general board resolution. And their view of life is, yeah, we're entitled to do it this way because Y Combinator has said that we can do it this way. And I don't know that that's the best advice, but I can tell you, I do think the entrepreneurs love the fact that they can generate these documents very quickly and get the money in. And then there's some day of reckoning that happens once the company gets funded with real Series A or Series B or Series C money that turns all of them into the Series A or Series B or Series C preferred stock. So that's kind of the big background to it. But from a tax point of view, I don't think they were really thinking, anyone was really thinking. And I think now people are starting to recognize, well, what is the tax view? What actually is the way this stuff is supposed to work? And
yes,
Combinator doesn't have any advice on it on their website that I could find.
They've got a disclaimer that's even stronger than the disclaimer that I've just been making up as I go along.
Right.
And I agree that I have not met the lawyer who wrote the SAFE agreement, but I've had a handful of clients who've used the SAFE agreement. Mm-hmm. And as you say, a startup CEO who's out there trying to sell something, they have to have a piece of paper that they can pull out to close the deal.
Right.
So they get a check and they give the writer of the check a piece of paper, and it's called a SAFE, where, as you've alluded, SAFE is an acronym that does not involve any thinking about taxes, and that may very well stand for unsafe, not safe.
Well, it's everyone's in the same boat, so everyone views it like, well, if you're in the same boat, then it should be okay. But the truth is, there may be a savvy investor, like a really savvy investor. Maybe they put more money in, maybe they don't. And they say, I'm not going to use a SAFE. I want a secured convertible promissory note, which is really the strongest form of document that you can get because it gives you a security interest over the assets. And that party will have priority over the SAFE agreements because the SAFE agreements are not, strictly speaking, written as debt. They're written as though they're more of some sort of option to have a right to convert into a future round. And I think in some of the literature that I've read, it suggests it's like a form of a forward contract, that it's like almost a future. It's almost in the nature of being a future that's targeted to a date when something is actually going to happen, like something's actually going to play out. And whether it plays out or not, we know 80 to 90%, sometimes even much higher, of startups fail. So, if you're doing this early stage investing, you got to be accepting that many, many startups will not succeed, that startups are not guarantees of anything. This is not like a corporate bond. It's not like a public company. It's really like, look, you're doing something that may or may not become anything, and just be aware that that's what you're doing. So tell us more about the tax side as you see it. And I know the disclaimers are there, and this is an area that's evolving. Right.
As to which party is in the strongest position and whether it's advisable or possible for either party to bring a lawyer into the situation, and how often that actually happens. Some of the key tax questions are, what is the security of this note? Is it similar to an incomplete transaction, which would be booked by the company at perhaps a subscribed stock? Or would it be closer to equity, where actually the recipient can start the clock on some of the tax benefits, such as the 83B election or the QSBS, a qualified small business stock, section 1202, on 5-year holding period?
Right. What people need to know is when you buy into an early stage company, and the company issues securities, like just take common stock, a clock starts running for capital gains purposes. That's the easiest clock. It's 1 year. A clock starts running for the benefits of Section 1202 of the Internal Revenue Code, which gives you special tax treatment after 5 years. Even on this, I used to be on the state side as well. I don't know if that's still true, whether it's both federal and state.
California does not conform to QSBS, so you pay the flat California tax rate, approximately 12%, no matter how long you hold the stock, whether it's 1 year or 5 years or a million years.
I mean, in the back of my mind, I thought California conformed for a while, and maybe that's gone away. I remember someone saying to me at one point, yeah, California is following the federal rule on 1202.
California
that's
is much less conformant and much less tax-friendly in a handful of ways than many other states. So unfortunately, that person was incorrect. California does not comply with QSBS.
Okay. So when you think about this, there actually are a number of intricacies that people just don't think about. And maybe if they could negotiate and just choose to say, give me common stock, but most times the company will not want to issue common stock to an outsider because their view is the outsider hasn't really earned it. The outsider's just putting money in. It's really outside money that's getting bashed with other outside money. And oftentimes the view is the outsiders are going to pay a much higher valuation than the insiders are going to pay. Now, whether the IRS will ultimately attack that on the view that the insiders are getting cheap stock and they shouldn't be getting such cheap stock, that's a different question. So ultimately, you have to be thinking about, well, can you write something into the SAFE agreement that makes it lean as more debt or makes it lean more as stock? And maybe you could have an addendum of some sort that sort of leans it one way or the other, depending on what your goals are, whether your goals are to start a clock. Because I think it can be essentially written one way or another, right? Like you can.
And that's a very important point, is that many SAFE agreements are not Y Combinator state SAFE agreements, but have been modified by the parties or by an attorney.
Right.
And so you can't just say, well, it's a SAFE agreement and therefore draw conclusions. You have to actually read each word.
Yeah, you could read each word and still not understand it. You could read each word and not understand that in theory, there should be an ability to negotiate. But, a lot of founders will say, look, if you're going to ask for negotiation, I'm just not going to choose you as an investor because I need, not that I need dumb money, but I need someone that doesn't make my life miserable. I need someone that basically can live with standard forms because I don't want to spend a lot of money on legal. And, in truth, the biggest risk that is out there is the company going to survive? And the more time that's spent on legal that's not producing intellectual property or some other value, the more likely it is that the company is not going to get to the finish line or not even get to first base because they end up spending too much time on what might be called unimportant legal. That is legal that's not really moving the needle in a direction that's going to actually produce real value for the company. So it's an interesting problem. And I'm sure there are lawyers that try to renegotiate safes, but I've seen many founders and CEOs say, I'm just not going to go with that investor. If that's the case, I'm just not going to do it.
At times, the power is in the other hand, and the person who has the cash has a significant amount of power to say no, to say, I'm going to invest in some other opportunity. You mentioned the starting periods for these holding benefits. There's also the question of what happens if the company fails, and what is your priority and claim on the cash you've just given the company? And in particular, can you get any cash back if the company fails before a conversion event that actually gives you stock?
Right.
But on the other side of it, there's also the question of a deduction in case the company fails. At what point can the investor deduct their loss, recognize their loss? And is the loss treated as a capital loss that only gets deducted $3,000 per year? Or can they deduct it as an ordinary loss and offset their other income? So those are some of the larger tax questions that I perceive in the thing.
Right. So you're saying in so many words, when you make the choice to lean it towards debt, yes, you get the benefit if it's a total loss of being able to deduct it as a total loss, not as a capital loss, because it's not stock, it's debt. Whereas if you actually lean the document towards being more like stock, then it may be interpreted by the IRS as stock, effectively, as equity. And then that equity is subject to the $3,000 a year cap, right?
There's also the potential, if you had something more like a partnership, of taking an ordinary loss instead of a capital loss. Reach out to me if you're in that situation and you need to do that. But yes, depending upon where on the scale this thing lives as to whether it's debt or whether it's equity, you would have various different possibilities for the treatment. Now, I'm going to hedge my bets and say usually or maybe in this, in particular, since today, the Supreme Court has decided to overturn the Chevron standard for allowing agencies such as the Treasury Department to set tax law. And they're saying that the courts must consider each situation and not just rely on Treasury Department regulations. Now, we've got perhaps 100,000 pages of Treasury Department regulations that up until now have defined how tax gets interpreted. And the Supreme Court has just decided that they're going to do something new going forward, but they haven't exactly clarified what they're going to do.
Let me just give 2 minutes of background on this. The Chevron deference standard that's been on the books now for probably at least 4 or 5 decades, maybe longer, was when an administrative agency issues a regulation, it's not only presumed valid, but essentially the courts are directed to defer to it, almost the way the courts have to defer to an arbitration award that's issued by a neutral arbitrator. And so the standard is very deferential. You have to show an abuse of discretions. In the case of an arbitrator, you have to show corruption. In the case of an administrative agency, you'd have to show there was some process violation. They didn't hold a hearing. They didn't consider evidence. You have to show something significant, because otherwise the presumption is so strong that the judge just throws the case out on summary judgment. This latest case that was decided today, it was kind of a favorable case for Trump after that debate that went so badly for Biden. But literally, the case is sort of suggesting all of the agencies in Washington, D.C. are going to be subject to some higher, stricter judicial review, which means they've really got to do their homework and do it very carefully before they issue regulations. And the regulations have to be, more than just rational. They have to actually be supported by evidence in a way that if they're challenged, they can be argued to be justified. And ultimately, that's really new. That could change securities law and the SEC. That could change commodities law and the Commodities Commission. And it can change tax law, as you said. And there's a gazillion other agencies in Washington, D.C. as well, where that could be impacted and probably will be impacted. And we'll probably see a lot more litigation about regulations over time. I mean, that's just the reality of what we're dealing with at this point. So you probably would expect to see ultimately more cases that go to court, right? That go to an adjudication on a go-forward basis, right?
So this perhaps provides an element of job security for both of us.
Well, maybe a lot of job security and maybe a lot of chances for Trump, if he ends up succeeding in office, to essentially say, this agency doesn't really do the work that needs to be done. Let's just strip the agency of a lot of its power. So I do have a few slides that I did prepare that I just want to show for a minute, just so people who view this on YouTube will kind of have a better understanding of what they're dealing with. And they really meant to kind of cover what we've been talking about and how we're talking about this area, because this area is sort of evolving over time and will continue to evolve. So founders get together, they get some common stock, and they try to attract investors, right? And so basically there's a cycle of negotiations that happen between the founders and the investors. And, counsel is usually involved in the startup of a company, but these days people go on LegalZoom, they go on a bunch of other Carta, they go on a bunch of other places, and they use automation to start their businesses. And they often don't get a lawyer involved until much later, and probably true for accountants too. You probably don't see the company right at startup. You probably see it after maybe the first year, and maybe even a few months after the first year, when they have to file tax returns. And then they come and say, hey, this is getting complicated. We have investors, we have a bunch of other things. And of course, that negotiation, you could argue why Combinator, through the SAFE document, wanted to make that much easier, much more streamlined. So what they came up with, and I'll send you these slides, but they came up with this idea of, we'll have a simple agreement for future equity that will be different than a convertible note. Now, this chart, which I picked off from this website called Financial Edge, it's not 100% accurate, because yes, a convertible note is debt, but some SAFE agreements, depending on their wording, may be viewed as debt. It says not debt. It's not saying what it is, but in truth, it could be viewed as debt. A convertible note that has a term sheet is somewhat more complex, whereas a SAFE tends to be shorter. There's typically not a term sheet. It's just the document itself. There's interest on the note, because notes have to have some interest rate. That's the whole nature of a promissory note. A SAFE has no interest. Founders like that. They don't want to feel like they're in the burden of adding more debt over time. Usually there's a maturity date, and somewhere in this, a lot of these SAFE agreements don't really even have a date. They're open-ended. And so there are valuation caps that usually apply to both, and then there are usually discounts that apply to both. So they're very similar. You were about to say something, Steve, before I go to the next slide.
I did want to jump in and say that there used to be something called a pre-money. It didn't really have a name, but it was more or less a pre-money SAFE agreement that was very, very commonly used throughout the 2010 to 2020 period. And right. I've had a handful of clients with subsequent problems relating to that earlier version of the SAFE agreement. This new post-money SAFE agreement that's now available on the current Y Combinator website is in many ways much closer to equity than to debt. And so it's important to, when looking at a situation involving SAFE agreements, to understand which version of the SAFE agreement was used. Was it the older pre-money SAFE agreement? And pre-money, the term is used to describe the valuation process. So the older agreement did not give a clear definition of how many shares were being sold, whereas the newer, quote, post-money, unquote, agreement actually specifies what portion of the company is being sold in general.
Right.
Now, on that note, in either case, the investor has to actually write a check before they have any claim whatsoever. And then they potentially don't get shares for an indefinite period. But with this new post-money SAFE agreements, which are about 4 pages of legal text, it's intended to be treated as if stock had been issued. So it's intended to start the clock on these tax matters.
Right. So they've gotten more sophisticated than where they were, say, back in 2017, or whenever they started. I think it's been close to 10 years.
Has yet to go through tax court. And the question of whether the IRS would allow this new SAFE note to actually start the clock is still in doubt. So the final answer is safest with stock.
Right. You're safest with stock if you want to get, and you believe in the company, you want to get the clocks going, and you believe in the company, and you believe the company will grow and succeed and not fail. You're safest with debt, and in particular, a secured convertible note, if you think it's a lot of money that you're putting in, and you think if the company fails, at least you want to get some rights over the intellectual property, or some rights over the invention, or some rights over inventory, or some rights over a customer list, so that you can do a restart of the company, or so that you could sell the company. Sometimes there are people that will buy collections of patents and try to monetize them. So there are spreadsheets that are available online that show how you do the calculations based on the discount rate and the valuation cap and so on. They've sort of automated this. So usually there's some investment agreement. Usually it starts as emails. While we say there's no term sheet, there is kind of an exchange back and forth by email. The discount rate is negotiated. Something is said about how pricing is going to go. Something is said about the number of outstanding shares. And if it's shares, you're going to receive a certain number of shares, like in the case of $10,000 at 80 cents a share, you're going to get 12,500 shares. That number sounds high, but if the company has 100 million shares outstanding, it's a relatively small number of shares. If it has 100 million shares outstanding and issued and outstanding, it could have 100 million shares that are available in its book, but maybe there's just 1 million shares outstanding. If there's 1 million shares that have been issued, then 12,500 or even 100,000 shares, just to use a round number, 12,500 would be 12% of the company. That would be a significant stake for $10,000. Obviously, the valuation of the company would then be under $1 million. So there are examples. I can make these slides available on the podcast. And people compare safes to convertible notes, but I think what we're saying is these comparisons are not necessarily accurate unless you see the underlying documents that are being compared, because those documents are really going to tell you how much do these safe documents lean towards being more like a note versus how much do they lean like being more like equity. And they can lean one way or the other. They're often, form documents, but there's probably at least 100 different forms out there from different people. And there are different calculations of what happens when the actual Series A round is closed and how the calculations go.
Secured convertible debt is safer than the equity. My comment about equity being safe was in comparison with the treatment as an incomplete transaction.
Right.
So you just give somebody the money and all they give you is one of these SAFE things that they had in their back pocket.
Right.
And that's not as safe as either equity or the even safer secured.
Right. So let's quickly talk about the cases I see often. They go like this. So I put $100,000 into this business and I say, what did you get? And they say, I don't know. I signed the safe agreement. Did you get a stock certificate? No. Did you get a receipt? No. What did you get? I have a receipt from the wire transfer or the canceled check. I thought I was buying, 10% of the company. In fact, my check says on it 10% of the company. But what I have that's the actual signed agreement is a safe agreement. And I said, what happened? Well, the company basically doesn't answer my phone calls. It looks like they've gone out of business, but I'm not sure. And they have a website. Yeah, the website's still up and it's still running, but no one answers the phone. No one answers the emails. And I've been told all the employees are gone. Okay, does it have any assets? Well, it has about a dozen patents. It's got a bunch of software. The software is still available in the App Store or whatever. I'm giving you the case where it actually seems like there's something still there, but all the people are gone, which of course is a very bad sign. And he says, well, what do you want to do? He says, well, I really want to get in there and get my 10%, because of course he's been sold on a view, or she's been sold on a view that the 100,000 was going to get 10% of the company. And now that the company is more or less defunct, they want to imagine there's a button you can press and get all those assets converted into cash and then get some portion of that 100,000 back. It doesn't work that way because the corporation or the entity, the LLC, the corporation, whatever entity, the safe that issued the safe agreement, same would be true for the convertible note. It's not in a position, unless someone's actually going to sell the assets, to have any cash. So there's essentially this notion of a zombie, which is a body that's around an entity that has no brain because all the people are gone, but it does have body parts and it does seem to still be sort of semi-alive, but no one's out there actually trying to sell any of the component parts. And so it can exist in zombie state for years. And what typically happens is eventually someone comes around and says, hey, I'd like to buy whatever I can buy to sort of see if I can get the patents or see if I can get some of the IP out of it. And if there's not cooperation, then there's nothing. There's nothing to collect. And so I have to say reluctantly to these potential clients, I really can't help you, because the truth is you'd have to get a bunch of people together, because this is something we haven't covered, and try to file for bankruptcy. But if it's not debt, you can't get the three people together that have the debt that can march the company into bankruptcy for unpaid debt, because the safe is not debt. The safe is, the argument would be, the safe represents this simple agreement for future equity, and it's not in default. It's waiting for some event to occur where there's a financing or an exit, and neither of those events have occurred. So it's very protective in some ways of the entity continuing to survive, even in zombie state, as opposed to debt, where three creditors can get together, push the company into bankruptcy, an involuntary bankruptcy, and then get a trustee to go through a liquidation process. And if their three people are all secured creditors, then they will have priority over everyone else, maybe even over employees. The only place they probably wouldn't have priority is over the federal and state tax authorities, who would have priority based on their super priority powers as taxing authorities, right?
I've had a couple of these zombies come to me for tax advice, and a few of them could even afford my fee.
Right.
And of those, they're either management or the management team, who often are trying to take the IP and spin the wheel again.
Right.
And
because the IP could be valuable. The IP could be valuable, and you could argue it's sort of like a joint venture that in the first go-round fails, and the joint venture being the investors were joint venture partners in a sailing of a ship that sank, but the ship had cargo, and the cargo can be pulled off of it in some smart way. The investors would like to have some of that pulled off cargo, but oftentimes the founders are like, that ship sailed and failed. And if you want to get on the new ship, you got to pay to play. You got to pay to do another startup. And in the most aggressive version of that case, the founder basically says, you weren't good investors. I'm not even going to let you into round two because you wouldn't put more money in to keep the ship afloat when we needed the money. So now I found new investors who are able to buy out the asset. I mean, that happens and people get pretty pissed about it. But I understand both sides of it, because the view is it was a risky venture to start with. You're an accredited investor if you're in this area to begin with, and you have to suffer your lumps. So there is a difference between a convertible note and a typical form safe agreement, and of course, common stock. And if you had common stock and the business failed, you would get zero. You would be below the safe, and you would certainly be below the convertible note, and the convertible note could be below a bank security interest if there was actually a bank line of credit, or below a secured note that could be out of it. So there's kind of a pecking order that plays out here. But the tax ramifications are important. And that's why I recommend that anyone that's got questions about that, contact Steve, because Steve's practice includes helping both investors as well as founders and teams that are trying to figure out, well, what do we have and how do we account for it? Do we account for it as debt, or do we account for it as equity, or do we account for it as something else? So Steve, tell people how they can reach you.
I will. Let me also say that the sooner you get professionals looking at your situation, the more we can do for you.
Right.
If we have to come in after a whole bunch of messes and do cleanup, our fees will be, and our time spent on the situation will be much greater. And you could have done the same thing and made a lot more money if you brought us in sooner. So you can reach me on my website, www.taxservice2u, the number 2 and the letter U.com. My cell phone is 408-887-6433. And thanks for having me on this program, Jack.
Thanks, Steve. I appreciate it. Talk to you later. Have a good weekend. We'll do this again. Bye-bye.
Tune in next time on The Valley Current.